Okay, good afternoon, everybody. I think we'll go ahead and get started. We always have a pretty packed agenda for our webinars. So I want to make sure we have enough time for some questions at the end for our presenter. So as usual, welcome to the HTRC webinar series. Today we will be hosting Rochelle Marting, and we will be talking about risks, red flags, and best practices when choosing a vendor for your telehealth program. As usual, just a note, this session is being recorded and we'll share it with you afterwards via email along with the PowerPoint presentation. Your microphones have been muted, so please unmute or use the chat to talk or ask any questions. Your completion certificates will be emailed, so it's important to sign on with your first and last name so we can identify you. You can update your name by clicking the three dots in the upper right-hand corner of your Zoom frame. So let's get started. I'd like to introduce Rochelle. Rochelle is a local attorney who is also a registered health information administrator and certified medical coder. Her practice focuses on medical coding, billing, and reimbursements, HIPAA privacy and security, health information management, and regulatory compliance. We're thrilled to have her today. Again, we will be talking about choosing a vendor for your telehealth program. Now I'll go ahead and turn it over to Rochelle.
Thanks, Molly. Well, maybe even before we jump into risks, red flags, and best practices, the primary topic for today, I always like to start these sessions out with any late breaking news, things that are going on in the world of telehealth, coding, billing, policy, and changes. When we started this educational series a little over a year ago, I think it might have even been longer than that, we had gotten through the initial wave of changes at the beginning of the public health emergency that happened kind of between March of 2020 and into May and the summer of 2020. At that time, we were really talking about what is the coding and the billing policy world with respect to telehealth. What are sort of the logistics and operational nuances that you need to know about what telehealth is and is not, and when you can and can't use it and how you bill it. Things were kind of steady for a while, but now we're kind of entering into an era where I think we're going to see lots of changes happening quickly. And in fact, the last several sessions that we've had have been about changes and updates and policies. So I think that's a trend you're going to continue to see. And actually today's topic comes from a recent Office of Inspector General report about risks that they're finding with telehealth vendors that I want to keep you apprised of. There has been some changes that I want you to know about, even in the last couple of weeks, that are putting us in a little bit of a topsy-turvy in terms of what's going on with telehealth policy and the future of some of the flexibilities that we had during the public health emergency. So if you'll think back a couple of months ago, we talked about legislation called the Consolidated Appropriations Act of 2022. And it took a lot of the telehealth flexibilities with respect to originating sites, geographic areas, the patient's home as an eligible originating site, distant site practitioners, PTs, OTs, and speech therapists, rural health clinics and FQHCs as eligible distant site providers of telehealth services, and made those available for 151 days after the PHE ends, whenever that happens. So the breaking news is that July 28th, at a federal level, the House passed a bill, 4040, that would take basically what happened in March and those same extensions, and rather than 151 days after the PHE ends, would make those available through December 31st of 2024. So as I start off, the very most important thing I want to emphasize is this is not official and final yet. This has passed the House. It has not yet passed the Senate and become law, but it's bipartisan and doesn't seem to be particularly controversial. In fact, leading up to this, there was a bipartisan effort to try to make these particular changes permanent, and they just couldn't reach an agreement on how that would happen permanently. So this was sort of the resolution to continue for about a 2-year or another 2-year period. So again, if finalized, because it is not yet law, this would make those particular flexibilities available through December 31st of 2024, regardless of when the PHE ends between now and then, knock on wood, assuming that it does end sometime between now and then. A couple of things that it does not do, similar or would not do, I should say, if it's passed. Similar to what happened in March of 2022, it would not make critical access hospitals eligible distant site providers of telehealth services when the public health emergency ends. And that was a really controversial piece that was in a proposal, in a proposed bill in February that didn't make it into the final Consolidated Appropriations Act that passed, and is not in this bill that has passed the House either. It would not extend anything beyond December 31st of 2024 on a permanent basis. It also does not capture the Ryan-Height Act that we've gotten a couple of questions through the TA email about the flexibilities in the 151-day period. The Ryan-Height Act refers to controlled substances that are prescribed in the course of a telehealth visit, and the requirement to have an in-person, face-to-face visit before controlled substances can be prescribed via telehealth. That's waived right now during the PHE. All signs point to that going away when the PHE ends. There was a proposal in February that the Ryan-Height Act would be extended for a period of 2 years after the PHE ends. That language did not make it into the final Consolidated Appropriations Act that ended up getting passed. It also is not in this bill that has passed the House that would continue certain telehealth flexibilities through December 31st of 2024. So those were the two big pieces that I saw are not in this bill. I will, the hesitation, I've got a link here for those of you that are interested in this kind of stuff. I pulled the House Rules Committee meeting, and you can kind of watch the video of it. And for those of you that are interested, it's between minute markers about 16 and 45. So you don't have to watch the full hour and a half, where they talk about this telehealth bill. They also talk about a bill on big cat legislation, if you're interested in that. But on the piece regarding telehealth, they talk about what the hesitation was, why they couldn't reach a final agreement to make these changes permanent, beginning now. And there's really two constraints. One is cost, and really not having a good sense yet of how telehealth may be avoiding other costs and where the money is going to come from to continue to make telehealth available in this way. So they're studying costs, and they felt like they needed some time. But program integrity is also a concern, as we're talking about today, a lot of the topics on different vendors. If you look at some of the fraud enforcement actions against different telehealth vendors, they are in the tens of millions, 40, 60, sometimes hundreds of millions of dollars. So that's absolutely a concern for members of Congress, that there may be increasing risks to program integrity that need to be taken into consideration. So those are the things they're hoping to look at further. They mentioned a few times in the hearing that there is a report coming out early next year. So we'll be watching for that the OIG is doing as part of their mandate under the Consolidated Appropriations Act from earlier this year, to study those exact things and to report back to Congress on it. So I think in the next 6 months or so, we'll see that report come out and have a sense of what direction Congress may be heading. Yeah.
Would you clarify the December 31st date is between 2022 and 2024? There's a little confusion in the chat box.
Oh my gosh. Yes. Thank you. I was typing 22 and 22 and 22. I'll correct these slides before and send them back to you all. Thank you. That third bullet should say, sorry for that confusion. Goodness. It would, if passed and finalized, extend these flexibilities that we have available currently for at least 151 days after the PHE ends, and would extend them through December 31st of 2024. Thank you for pointing that out. I'll add one other piece that the Consolidated Appropriations Act already took into consideration or extended for 151 days after the PHE ends, that this bill, if it passes, would also extend through December 31st of 2024, is the in-person visit requirement prior to a mental or telehealth visit to a person, to an individual who is at home or outside of a rural geographic area. That was written into the act that made those telehealth services available, that 6-month in-person visit requirement. So Medicare's limitation after the PHE was they did not have the authority to waive that. It had to be an act of Congress. So this also extends the waiver of that requirement, meaning that 6-month in-person visit requirement for a mental or behavioral telehealth visit to a patient at home or outside of a rural geographic area at the earliest would not go into effect until January 1st of 2025. So I think that's a great flexibility for providers that have been concerned about that. So they're still in talks. A lot of the members of Congress that you'll see if you watch this committee hearing are interested in making these changes permanent. Now, I looked at the members of the committee. We actually didn't have any Kansas or Missouri representatives that were on the committee during this hearing. There was one from Oklahoma. So if you want to pull up the information and see how that representative voted or what their opinion was, certainly for this group, that might be important for you to take a look at. But I think that this really sheds light, I felt like, on the direction of telehealth policy becoming permanent once Congress can get comfortable with budgetary issues and program integrity concerns. All right, so diving into the actual topic for today is a recent OIG report came out on some indicia of potential red flags or risk areas in working with telemedicine companies. And knowing that program integrity is one of the primary concerns that's holding Congress back, and knowing that a lot of providers, particularly in our regions, are working with telehealth companies to help support our telehealth programs, I felt like this was a really important topic to dive into. What are those risk areas? What are the trends that the OIG has seen in the telemedicine companies that they have investigated and taken enforcement action against, so that you can be aware of those? And we'll kind of talk through some processes and suggestions for due diligence that you look at whenever you're considering entering into an arrangement with a telemedicine or telehealth company. So I'm going to start with kind of where this OIG report came from. There have been congressional mandates for the Office of Inspector General and the Department of Justice to investigate program integrity risks related to telehealth. Some of this are newer mandates as a result of the extension of telehealth for 151 days after the PHE that happened earlier this year. Some of this has just been ongoing efforts over the last several years on the expansion of telehealth. There was a really cool statistic in this report. I think it's interesting. Back in, I want to say it was 2001, maybe 2006. I can't remember. Oh, it's 2001. The total spending for telehealth for the entire country that year was $61,000. And so you can just imagine how much it has expanded and exploded, particularly in the last couple of years. So program integrity investigations are definitely a focus of the agencies and an interest of Congress to continue to make this available. We will see more reports. This was primarily a product of a lot of recent enforcement actions against telemedicine companies that have really exploited and taken advantage of the expanded access to telehealth, particularly audio-only telehealth services, and really taken advantage of healthcare providers and gotten healthcare providers in trouble for arrangements that probably in any other industry would make a lot of sense, that cannot be done in the context of healthcare. We're going to be seeing more reports from the OIG on program integrity, coding and billing risks for different arrangements with telemedicine companies. So this is probably the first in a series of reports and investigations that they're doing. What this report does, though, is take a lot of the recent penalties against telemedicine companies and sort of outlines commonalities in the way that they were structured or in the payments that were being offered as sort of a, hey, providers, these may be some, not necessarily that any one factor is illegal or wrong, but this might be an indicia if you're looking at an arrangement with a telehealth company to make you pause and say, we need to vet this out a little bit further. So kind of stepping back into how healthcare providers work with telemedicine companies or other vendors to deliver services that maybe aren't in-person, face-to-face services. One of the primary statutes that comes into play that's problematic or potentially problematic in these arrangements is called the anti-kickback rules. And the anti-kickback rules say that it is a violation of law, a violation of the conditions of payment under Medicare to offer or to receive what's called remuneration, anything of value, in exchange for making referrals for services that may be paid in whole or in part by federal healthcare programs. So breaking that down a little bit further and saying it maybe simpler terms, you can't, both sides of the transaction are problematic. Offering to give someone something of value in exchange for referrals is problematic. Receiving that something of value in exchange for referrals is problematic. Remuneration might be money. That's probably the most common something of value that's offered or received, but it's also, it could be, elaborate lunches, expensive dinners, vacations, and that kind of thing. That's why a lot of offices don't do the pharmaceutical companies' lunches and breakfasts and notepads and pens and all of the little the goodies anymore because of the anti-kickback statutes. And that was one of the areas that the OIG is finding is often implicated in these problematic arrangements in the way that they're structured. Again, a telemedicine company that's offering to pay a healthcare provider something as part of their arrangement, that is not necessarily in and of itself problematic. We'll talk about how this is coupled with other factors that really becomes the issue. Now, typically, the federal anti-kickback rules, they're prohibiting this offering or receiving something of value in exchange for referrals of services that can be paid by federal healthcare programs. So we've traditionally thought of that as a Medicare, Medicaid, TRICARE rule. But most states have anti-kickback laws that are sort of state law counterparts to the federal rule. And some states it may only apply to Medicaid, in some states it may be an all-payer anti-kickback rule to keep in mind. The other thing to keep in mind is that it's not only problematic, the anti-kickback laws are criminal statutes, so it could come with both monetary penalties as well as criminal penalties, which could mean prison, as we see in some of these cases with telemedicine companies. But also where there are kickbacks, there are often false claims, meaning ultimately you're offering or receiving something of value in exchange for a referral. And then ultimately when that service gets billed to the federal healthcare program, that can be a false claim because it's premised on an improper order for items or services under the program. So that's kind of the legal background on where some of these arrangements can get both sides of the transaction into trouble. So I want to shift gears a little bit and talk about some of the things that the OIG has found as commonalities in these arrangements with telemedicine vendors that have gotten folks in trouble. So one of the factors, one of the ways that these arrangements are structured is that the ultimate provider typically ends up having limited, if any, interaction with the patients themselves. So this could look like the telemedicine company working with your providers, sending you medical records so that your providers can review, certify the need for durable medical equipment, write scripts, write orders for imaging, write orders for other items and services, but maybe not interacting with the patient at all or on a very limited basis. Look for the words in the arrangement per review. You've probably heard of per click issues, same concept, per chart, per case, per order, referring to these as consults or chart assessment type payments. Not necessarily in and of itself problematic, but the OIG is saying that's a trend, that the overall substance of the arrangement could be something you need to look into further that may cause problems with these anti-kickback or false claims rules. One of the things they're seeing is the vendors make it look like they're trying to make this really easy and not burdensome for your providers at all. We've got the patients, we'll collect the charts, we'll give it to you. You don't even need to contact the patient. In fact, we don't want you to contact the patient. That sell that this is really nice and easy, you're just reviewing charts and getting paid for your chart review and you don't actually have to talk to the patients, can be problematic because there's often not a verification that the charts that the provider is getting are actually legitimate medical records for actual Medicare beneficiaries, and we tend to have issues there. Any indication that the company is sharing only pertinent medical records or limited records like demographic information, maybe a diagnosis code, rather than the full medical record, can be a problem. If they are not willing to provide the full medical record, we only send a subset of 3 documents for each patient. That is the scope of what we want you to review. That could be an issue. Also look for arrangements where the vendor has pre-selected the test that they're interested in, the medication, the item, the service. So they're wanting your review to see if this patient meets criteria for genetic lab testing as an indication of precursors for cancer, or for durable medical equipment, or for certain high cost pharmaceutical drugs or items. So when they kind of have that item or service pre-selected for the provider's review, that's been a sign of a potentially problematic arrangement. A lot of these companies that have gotten in trouble and gotten providers in trouble describe themselves as a telehealth or telemedicine company, but really function more as telemarketers than telemedicine. So they may be out there going door to door to seniors, or making phone calls to individuals and kind of doing the recruitment and getting the patient base. They're bringing the patients to the provider saying, hey, we've got this pool of patients that may qualify for, insert the name of a test or a medication or a piece of DME. So that's potentially problematic. And the ultimate messaging that's going out to the patients through the door-to-door marketing or through the telemarketing campaigns is, you may be eligible under your Medicare benefits to receive this item or this service or this test at very low cost or no cost to you. And that's the messaging for the patients that then leads to the compilation of records that then goes to the ultimate providers to review and certify or enter orders or enter prescriptions for different tests and services. One big risk area is if you're entering into an arrangement with a vendor that only focuses on Medicare beneficiaries, Medicaid, or individuals who are covered by programs under federal healthcare programs. That's definitely a risk area. No need to follow up with the patients, or especially if the provider doesn't have the ability to do so. That's concerning. The last item, or one of the last items that the OIG pointed out, is some of these telehealth or telemarketing type vendors maybe reaching out to providers' offices and facilities, almost like a phishing scheme through email, saying, hey, provider Marty, one of your patients may qualify for this genetic test. We just need you to approve the test so that we can do that. What it's doing is creating an order from a healthcare provider that ultimately gets billed as a test or service that may not meet coverage criteria. But when our provider has entered that order or that script, we're part of that transaction that ultimately may not be up to par in terms of requirements and regulations. So coupled with this report, a couple of years ago, there was, even before the COVID public health emergency, OIG had already begun studying some risk areas in telehealth vendor arrangements and telehealth arrangements. Some of the things that they're looking for that can be problematic is whenever there is a claim for the distant site provider's fees for a telehealth service, but there is no corresponding charge for the originating site fee. That might be an indication to them that the service did not meet all of the covered telehealth requirements. The reason that used to be a problem before the PHE that maybe will not be as much of a problem now or afterwards is that, remember, before the PHE, the originating site had to be a healthcare location with very, very limited exception. It had to be a provider office, a critical access hospital, an FQHC, an RHC. So the idea was typically if you're in an eligible originating site, they're probably billing for their originating site fee and collecting for that. When the originating site fee is missing, that might be an indication that the service was provided to a patient at home or at a location that was not an eligible originating site. And when the OIG did their investigation, they found that was in fact a trend that they saw. No originating site fee tended to mean that the patient wasn't at an eligible originating site, meaning the distant site provider service could not be paid either. The provider was located outside of the US. That was a very small number, but that could be temporarily physically located outside of the US, like on vacation, but that's a payment prohibition. The telehealth service, the distant site provider cannot be outside of the US at the time that the telehealth service is rendered. Or a permanent arrangement with a telehealth vendor with physicians, even if they are licensed in the state where the patient is located, if they're physically located outside of the US at the time the service is rendered, it's not a payable service under the Medicare program. Now, this part I think is interesting. This study only looked at 100 claims. That is a really small sample size. And out of that 100, they found that 31 did not meet requirements and used that to extrapolate that there could be 3.7 million in overpayments related to telehealth services from such a small sample of claims. So that initial finding was a lot of the issues that OIG is finding could be prevented through different claim edits, both on the provider side and on the payer side. So for example, Medicare contractors could create edits where they don't pay a distant site fee if there's no corresponding originating site fee, or maybe they initiate prepay review to verify that those requirements have been met when there's not corresponding fees. That was actually the biggest concern from this audit. But if the elimination of rural geographic areas and eligible originating sites goes away on a permanent basis, the way it looks like it might, that takes care of about 24 out of these 31 improper claims that Medicare originally found in 2018. So really what we would be looking at in terms of our arrangements with vendors might be this component here, that we have a requirement in our contract with the vendor that their providers will be licensed in the state where the patient's located, that they have a process to verify the patient's location at the time of service, and prohibits their providers from rendering telehealth at any point from outside of the US to make sure that we're not running into payment problems there. Arrangements that waive the patient cost sharing amount with respect to telehealth can also typically be problematic. Although during the public health emergency, the OIG has a waiver, and I've put the link here in case you want to kind of store this for your own program purposes, saying that providers that waive patient cost sharing for telemedicine during the PHE would not be subject to civil monetary penalties under the anti-kickback statute. The anti-kickback statute comes into play because as a provider, if you are offering something of value to anyone in exchange or to induce the purchase of services that can be paid by by federal healthcare programs, that could be a kickback. That includes routinely waiving patient cost sharing, because that can be seen as an inducement to for patients to purchase your services that will ultimately be billed and paid by the Medicare program. And the thought is that could lead to unnecessary services if the patient's not asked to pay their fair share of cost sharing, absent financial hardship or bad debt or other payment policies. But just routinely advertising, come to us, we don't bill you for your copay, your coinsurance, or your deductible as a Medicare beneficiary, typically can be problematic. We'll want to keep an eye on that policy bulletin. This is another area where we may see regulatory changes, adding that as a permanent exception to the anti-kickback statute after the PHE ends. But absent some regulation from the Department of Health and Human Services, this waiver will go away when the PHE ends. And anybody who's been using that waiver to waive cost sharing for telemedicine services to Medicare, Medicaid beneficiaries would need to make sure they re-implement that process and probably notify your patients before the PHE ends that billing process would be reinitiated. All right, so before I get into some suggestions on what I see as maybe some due diligence steps in the contracting process, I just wanted to highlight a few of the telemedicine enforcement actions from the OIG and from the Department of Justice, so you can kind of see the arrangements that prompted this report from the OIG and some of the commonalities of problematic arrangements between telehealth companies, or I don't know if telehealth is really even the right word, telemarketers, those positioning themselves as telemedicine or telehealth vendors working with healthcare providers. So this is the headline: Georgia nurse practitioner was convicted of fraud in a complex telemedicine scheme. So this was an arrangement where the vendor that this nurse practitioner was working with engaged in a telemarketing campaign to reach out to seniors and advise them of their potential eligibility for these orthotic braces. And that telemarketing campaign, if they got a hold of an individual who was interested, they would collect some basic demographic information. You know, if you just give me your name, your address, your Medicare number, what I can do is get some information to a healthcare provider to see if you're eligible. So you can almost envision what the conversation is like. A lot of individuals would give that information, and then the nurse practitioner would review a limited subset of medical records and sign off. You know, what's the harm in saying, sure, this individual can have a brace if they need it, that's fine. Would sign off on these DME orders, and then that telemarketing company would sell those orders to a DME supplier that's enrolled in Medicare. So they're then going to the DME supplier and say, hey, we've got sort of a captive list of 1,000 signed DME orders. We just need a provider to fill those orders and to provide these braces that someone else has already certified. So it sounds really attractive, right, to the nurse practitioner. Like, you've got the patients, they just need these devices. You know, doesn't really sound like a high risk area. What could be the harm in giving someone a brace if they want it or if they need it? Sounds great for a DME supplier. We've got patients who need it. If we've already had a healthcare provider certify the need for the brace, we've got the orders. We just need a supplier to fill those orders. But it's really the telemarketing company sort of mischaracterizing at each step in the process what was going on, and the nurse practitioner got wrapped into that enforcement action for tens of millions of dollars. The owner of the telemedicine company themselves pled guilty to a healthcare fraud conspiracy. This one involved genetic testing. So genetic labs, genetic testing, DME, high dollar pharmacy tend to be the real risk areas in these arrangements to keep your eyes and ears open for. This vendor was going door to door, old-fashioned sales tactic, to collect specimen. Really easy process. So what we can do, Ms. Marting, with this sample, it's covered under your Medicare benefits. We do a swab, and the results will tell you if you have any indicators that might put you at risk for developing cancer or other chronic conditions. No cost to you. We'll take care of all of it. You'll get the results. And, it sounds great, right? Enticing to the individual. They then take those specimen, sell the specimen to labs that then would turn around and run the tests of these high dollar genetic tests to individuals that didn't have a need for it. These are not covered as screening tests under the Medicare program. Would run the tests, they would get billed to Medicare or Medicaid. In this particular instance, it was the telemedicine company. I have not seen whether the lab ultimately had any responsibility in that as well, but that could definitely be a risk area for the lab that ultimately submitted those bills. So let's talk about a couple of tips, tactics, strategies, really in the initial due diligence process that I think can help healthcare providers looking at potential telemedicine vendor partners to make sure they're on the up and up, and that we don't run into some of these problematic arrangements and structures. The first one I would say was, who called who? Are you, as the healthcare provider or the facility, out seeking a potential vendor, or are you getting a cold call about this really exciting new program and service that's low burden to you? It's a great benefit to patients. It's no cost to them. If it sounds like a marketing ploy, if it smells, what's the saying? If it looks like, sounds like, smells like, it probably is a scheme that may not be up to par with our Medicare rules and requirements. So that's maybe the first thing. Not that that's necessarily a bad thing if you've got telehealth vendors reaching out to you. That's certainly happening a lot, but one thing to look at. Whenever I start the contracting process, I always get the full legal name of the entity. And the first thing I find out is where they're organized, what state they were organized in. And I go look that exact full legal name up in the state where they were created. If I can't find it, that's my first sign of a potential problem. And what I'm also looking for there on the Secretary of State website in the state where they were formed, how long have they been in business? A lot of states, not all of them, will give information on owners, officers, and directors. So I look at that information. I also look at any fictitious names that they've registered. So their full legal name may be, Rochelle Marting LLC, but they may go by Awesome Telehealth or, other doing business as names. So I'm collecting all of that information. And in that process of collecting not only their full legal name, but also DBAs or other fictitious names, I start to look for other states where they may be registered, like the state where our healthcare provider or facility is located. Are they registered to do business in our state? If so, I'll go through the same process. What's their full legal name? Do they have other DBAs in our state? And if it's not a match in their home state, why is the list different? Trying to look for things like shell companies or, complicated arrangements where money could potentially be passed through in different ways. At the same time, I'm also making a list of those entity names and these individuals that are owners, officers, and directors wherever I can. Because before I enter or before I work with providers and facilities on entering into those arrangements, we run them through several searches and screens. And one of the most important ones to search is the OIG list of excluded individuals and entities. There are several ways you can do this. You can go directly to the OIG website and enter one or up to, I think it's up to 5 names at a time, or you could put it into you can download their spreadsheet of the full data set and search those. I just use a tool where I upload a file and it searches that data automatically. So that's one of the things that I'm looking for. If there is a match, that is not a vendor that we enter into a business arrangement with. There's also another government database called the SAMS database, and OIG is focused on individuals who can't participate in federal healthcare programs, where SAMS is a little bit broader. It includes everybody on the OIG list, but also other individuals or contractors who just can't have contracts with the government, period. It doesn't matter if it's healthcare or building a road. There's been some problem that would prevent them from being contracted. So I searched that too, even though the OIG is kind of the key one, because sometimes we have individuals cross industries. Maybe they were in construction, now all of a sudden they're a tech startup working in healthcare, because there can be big business and big money there. I go to their website, especially in the context of telehealth and telemedicine. These vendors probably have a website, right? Because we're talking about kind of a techie company. If I can't find a website, that's not necessarily a problem, but it's something that I want to learn more about. Are they new? If they're new, what kind of infrastructure do they have? What kind of their own procedural safeguards do they have in place? How sophisticated are they to make an informed decision on whether we enter into that arrangement? I also do a general web search, just going on to Google or Yahoo or whatever your preferred search engine is, and looking for that company or some of the names of the owners, officers, directors. Sometimes you find some really interesting information about their backgrounds or arrangements that they've been involved in, or lawsuits, maybe not related to billing fraud, but just other general business things that you may want to be aware of. If it is a type of healthcare provider that is licensed in a particular state, like let's say we know with this telemedicine company, we're going to be assigned Dr. Marting to help with our telehealth services. So sometimes in your contractual arrangements, you'll have an appendix of who those providers are that will be assigned to you, their name, their NPI number, and maybe even the states that they have licenses in. So you can go to those states, Board of Healing Arts or whatever the agency's called in the particular state, and verify that that individual has an active license in good standing. Do they have any disciplinary action against them? And if we're deciding to move forward, we may ask that our vendor keep that list updated as there are any changes in the providers that are working with us, so we can do that due diligence anytime that individual changes. It has happened more than once that an individual in the state that they're going to be working in didn't have any issues, but did have licensing issues in other states that we learned about through that due diligence process. And then, of course, before you sign the dotted line, read the contract. Does it have any of these buzzwords or structural arrangements that the OIG's already done the work for us that we know could be potentially problematic? If so, we may want to pause, dig further into that arrangement. If you've got legal counsel that you work with, have them take a look at it to make sure if there are any potential implications of the kickback statute that you're either meeting a safeguard, an exclusion or a safe harbor, or you've got appropriate safeguards in place to mitigate potential risk and make an informed decision about moving forward with that arrangement. So I've done a lot of talking about telemedicine vendors and some of the risk areas where they've gotten in trouble, and this due diligence process in initiating the contract. I'll pause there. Do you have any questions about that?
I don't see any additional questions coming in the chat. I will let everyone know I did drop a couple of those links in. They will be in the presentation that we send out, but I wanted you to have access if you wanted to check these things out sooner. So the first link was the rules video. at the 16 to 45-minute mark that Rochelle pointed out. The second was the OIG waiver during the PHE that she listed. And then the last, I did give you the main telehealth page for the OIG. There's a lot of information in there, but you can click around it and kind of play with that and see what you may need to look at or review regarding anything related to the use of a vendor.
Great. Well, if we don't have any specific questions, one thing I'll point out is this looks like a lot of work at the beginning of the contract process, and it is. But having this process in place is a really good protection in the event the vendors that you're working with are excluded from participation in federal healthcare programs. It's going to save a lot of time and headache to catch that up front than to find out about that later. Just kind of estimating for a typical contract, this process would typically take about an hour. And if you think about it in that way, this is a big program. It's an important program. There's a lot of healthcare access, patient care quality, and frankly, federal healthcare dollars that are at stake, as well as risk if you don't do it the right way. So that 1 hour of time, I think, is just really important that you have the confidence that you're entering into an arrangement with a company that doesn't have any major red flags or problem areas on its record before you even get started with your arrangement.
And I may also add, review some of the resources you have within your own organization that can maybe help you go through a contract as well, if they've been used to it. Some places may have contract specialists depending on the size. Others may have their own general counsel that they use, different things like that. And I'm sure you're all aware of what those processes are within your
Absolutely, absolutely. And I mean, that's a great point too. If you don't have this sort of due diligence, contracting procedure, review, approval, execution process in your organization, depending on your size, it may make sense to sort of outline that in a policy and who's going to do what and at what stage. Even major health systems really struggle with who's going to have the authority to make a contract request, who does the due diligence, who's going to do the contract review, and who finally executes. So contract management, regardless of your size, is definitely a challenge. But these are some great things to put into maybe the initial ask. I've had several organizations where, department managers or directors may have the authority to initiate a request for a contract, but maybe not the final signature authority. So when they make the request, they may be asked by the organization and some of the internal processes to have some of this information available. What's the full legal name? Who are the owners, officers, directors, or what's their website or the state that they're organized? So whomever is doing that due diligence process, before we really invest a lot of time and resources into reviewing the contract itself and getting into the nuts and bolts of the arrangement, that due diligence step, we've got that information kind of ready and packaged up. So those are all processes within your organization that kind of vary who does what and at what step to take a look at as well.
We did have a question in the chat box. Are there any typical or even likely things that qualify as kickbacks?
Yeah, well, money is the primary one. Now, that's kind of the general rule, the prohibition on offering or receiving anything of value in exchange for referrals. But take like a physician employment contract. The hospital is offering something of value, a job, a salary, in exchange for what will inevitably lead to referrals. That there's an exception for that. There are tons of exceptions to the anti-kickback rules that we certainly don't have time to go through all of those today, but just having that general awareness as sort of an issue spotting, the exchange of money, paying someone for something that may translate to referrals, that it's volume based. You'll hear per click, per chart, per assessment, per referral, however you want to word that, where it's just kind of an issue spotting thing that we need to be aware of. There very well may be an exception that makes that a perfectly permissible agreement, but those are just some of the signs that we want to look out for to make sure we refine it and have whatever procedural safeguards we need in place to meet those exceptions or to mitigate potential risks of a potential kickback issue.
Are there any other questions about this topic for Rochelle? Well, as usual, we will be sending out a follow-up email with the link to the recording, along with the links that I also dropped in the chat box. You can always email the Heartland Telehealth Resource Center afterwards if you have any questions that come up following the webinar. I think at this time, we're going to actually end about 8 minutes early, unless there's any other questions for Rochelle. Keep your eyes open on your email. We will be looking at our September topic. We already are into August. I can't believe it, but we will be getting in touch with everybody and letting you know what our next topic will be in September. We will be sending out some new policy alerts, so keep your eyes on that. With the fast-moving changes within telehealth and all the public health emergency flexibilities, we want to make sure we keep you up to date. So we're working on a nice, easy way to get that information out to you. So thank you for your time today, and look for your emails and let us know if you have any questions.